Welcome to FedSoc Forums, a podcast of the Federalist Society's practice groups. I'm Nate Kazmarek, Vice President and Director of Practice Groups at the Federalist Society. For exclusive access to live recordings of FedSoc Forum programs, become a Federalist Society member today at fedsoc.org.
Hello, welcome to this FedSoc Forum webinar call. Today, December 8th, 2025, we are delighted to host this Courthouse Steps oral argument program on Trump v. Slaughter, which was argued earlier today before the court. My name is Matthew Sawtell. I'm Assistant Director of Practice Groups at the Federalist Society. Please note that all expressions of opinion are those of the experts on today's call, as the Federalist Society takes no position on particular legal or public policy issues. In the interest of time, we'll keep the introductions brief, but if you would like to know more about any of our panelists, you can access their full bios at fedsoc.org. Today, we're fortunate to have Bilal Saeed as our moderator and Eli Nachmani as our speaker. Mr. Saeed is Senior Competition Counsel at Tech Freedom, and Mr. Nachmani is an associate at Covington & Burling, LLP in Washington, D.C., where he practices antitrust law and regulatory litigation. He clerked for Judge Stephen Menashe on the Second Circuit. His Alabama Law Review article, The Original FTC, was cited by Judge Rao in her dissent in Trump v. Slaughter at the D.C. Circuit, as well as by the government in its reply brief at the Supreme Court. One last note throughout the panel, if you have any questions, please submit them through the question and answer feature in Zoom so we have access to them when we get to that portion of the webinar. We do ask that the questions submitted there both pertain to this discussion and end with a question mark. With that, thank you for being with us today. Mr. Saeed, the floor is yours.
All right. Thank you, Matthew. All right, Ellie, let's just jump right into this. But before we do, I want to say I expect the majority, whatever that majority is, will cite your article as well. But we'll see. So let me ask you to just let's set the table, bring our participants, listeners up to date on why we're here, and then we'll talk about how the argument went.
Well, thanks so much, Bilal. Great to see you, and kind of you to say that. So this is a case that calls into question a precedent of the Supreme Court that's been on the books for a little while, Humphrey's Executor v. United States. What happened here? When President Trump took office in January of 2025, he started to look across the federal government, and there are several independent agencies. And when we say independent, at least in this context, we mean these are agencies that Congress has provided by statute for only limited grounds of possible presidential removal. Often, and as is the case with the Federal Trade Commission, the president can only remove for inefficiency, neglect of duty, or malfeasance. The president decided to remove a commissioner of the Federal Trade Commission. In fact, he removed two commissioners of the FTC, but we're up at the Supreme Court only as pertaining to one of those removals. The commissioner he removed in this case is Rebecca Slaughter. But instead of saying, I am removing you for inefficiency or for malfeasance, the president cited no reason and said, in fact, I can remove members of the Federal Trade Commission for any reason that I want because the statutory removal protections are unconstitutional. They contradict Article 2 of the Constitution. Of course, Commissioner Slaughter, or then removed Commissioner Slaughter, sued. She wanted her job back. And this case has wound its way through the courts. It was at the District of Columbia. It was at the D.C. Circuit. It went up originally in an emergency posture, and then the court granted writ of certiorari and is now considering the case. The case presents two questions, and the first is whether the statutory removal protections for members of the Federal Trade Commission violate the separation of powers, and if so, whether Humphrey's Executor v. United States should be overruled. That's question one. Question two, and I want to linger on question one for just a moment before we get into the discussion, but question two is whether a federal court may prevent a person's removal from public office, either through relief at equity or at law. So the second question goes to, okay, let's say Commissioner Slaughter is determined to be right, that the statutory removal protections do not contravene Article 2, that President Trump was validly limited by Congress in the promulgation of these removal protections. can a federal court even do anything about it as pertaining to Ms. Slaughter's job? But that's that first question. The court seems to distinguish between whether those statutory removal protections violate the separation of powers and whether it needs to overrule Humphrey's Executor v. United States. Briefly, Humphrey's Executor v. United States is a case that the court decided 90 years ago in 1935. And in that case, the Supreme Court said that President Franklin Delano Roosevelt's purported removal of Commissioner William Humphrey of the Federal Trade Commission was unlawful because the removal protections in the act were constitutional, that the Congress was able to limit the president in carrying out the removal at will of Commissioner Humphrey, because the commission exercised what the court described as quasi-legislative and quasi-judicial functions. We'll get into that today, I'm sure. And so the question now is, number one, is that right? And number two, is the reason that it's right or wrong today because Humphrey's executor is wrong, or, and this is something the court gets into, and this is kind of the thesis of my own article, that the powers and the functions of the Federal Trade Commission are so different today than they were 90 years ago when the court decided Humphrey's executor under the original FTC Act. Are they so different today that Humphrey's executor just does not apply anymore? So the court heard oral argument in that case this morning, and we anticipate a decision from the court sometime before July of 2026.
So let me ask you to explain to our listeners first, actually, how the powers of the agency are different today than in 1935, because that is a core point of contention between the parties. So before we ask how they did or what they argued, what are the differences?
Yeah, absolutely. So the powers of the FTC as they were in 1935 were very similar to what the powers were when the agency originally came into being in 1914. And you could classify those powers into three buckets. One was the agency could make reports for Congress. Okay, when the Supreme Court describes what the FTC did as quasi-legislative, a lot of people think they're talking about rulemaking. It's not what they were talking about. They were talking about making reports to Congress to recommend certain kinds of legislation, saying to Congress, for example, hey, there is some sort of consolidation in XYZ industry. You ought to think about doing something about it. There might be an antitrust problem here. Okay, that was one. Another power was that the FTC was able to act as a special master in chancery as an adjunct to a court. Importantly, not a court, but as an adjunct to a court to recommend the appropriate remedy in a judicial proceeding in an antitrust case. Okay, this was a sort of special master function. Okay, that was another power. And the third major power was that the FTC could issue cease and desist orders after going through a whole process of adjudication. There would be a complaint about a given entity that the FTC would say you are engaging in methods of competition that are unfair. There would be a sort of adjudicatory proceeding at the commission, and the commission would issue a cease and desist if it determined that, in fact, there was an unfair method of competition taking place. And then there would be a back and forth. If then the entity did not obey the cease and desist order, then the FTC could go to court. You could obtain a judicial order in something that looked like a contempt of court proceeding. The court would generally defer to the FTC's factual findings. And at that point, then there would be compliance, but really it would be mandated by the court. Okay, over the years, Congress has really expanded what the FTC's ambit is and the powers that it has. That suite of powers that I just described to you are what the court in 1935 described as quasi-judicial and quasi-legislative. Today, the FTC can do a number of other things. Number one is it can go directly to federal court and bring enforcement actions under, let's say, the antitrust laws that you're engaging in unfair methods of competition. The FTC also now has the power to enact penalty-backed commands. So it used to just be the FTC could say cease and desist from engaging in conduct violative of the antitrust laws. Today, however, what the FTC can do is obtain monetary penalties from folks. That's also an expansion. And also another kind of major addition to the FTC's powers is that just a few years after the decision comes down on Humphrey's executor, the court establishes that the FTC's jurisdiction would essentially expand from mere antitrust also into consumer protection. So now the FTC has the power to prescribe unfair and deceptive acts and practices. And later on, the FTC gets a rulemaking power to flesh out the meaning of the term unfair and deceptive acts and practices. Now, some people will say, well, the FTC always had a rulemaking power under the antitrust laws. That's a contested proposition of law. It's not obvious that the FTC had that power in 1935. And if you read Humphrey's executor, the court seems to assume that the FTC does not have such a rulemaking power. In any event, taking these things all together, you now have an agency that brings original actions in federal court, sometimes going through the process of adjudication. You have an agency that can go after private actors for financial penalties as opposed to just issuing cease and desist orders that it would need to go to court to enforce. And you have an agency that now engages in pretty robust consumer protection rulemaking pursuant to the Magnuson-Moss Warranty Act from the 1970s. And so you take all these things together, and even if the court was right in 1935, and I'm not sure it was, but even if it was right in 1935 that the FTC was then not exercising executive power, and thus it wasn't a constitutional issue to carve out the president's plenary power to remove members of the FTC, it seems today that the FTC's powers are far more expansive than they were in 1935, and that should not only affect the constitutional analysis, but also affect how we think about the applicability of Humphrey's executor today.
Again, before we jump to the arguments, maybe 2 minutes on Humphrey's, and was Humphrey's, I don't want to call it an outlier, but of course it does seem in some ways contradicted by the earlier case of Myers. So maybe just identify a little bit of that tension there.
Yeah, absolutely. So there had been a back and forth about what exactly the president's power is to remove agency officials. And then maybe more importantly, let's assume that there is that backdrop rule, which I think was by then pretty well established, a backdrop rule that the president may remove members of the executive branch, although maybe it's controversial to call the FTC part of the executive branch. But there's a background presumption the president can remove. There's a second order question. Can Congress regulate that removal? So, right, even if we agree that the president has that removal power in the background, can Congress add additional limitations onto it? The court avoided answering this question in a few cases leading up to the 1920s. So one example is Shurtleff v. United States, where the court interprets a provision conferring a removal protection in a way to ensure its constitutionality. But the question is squarely presented in Myers v. United States, where you had the removal of a postmaster. And so this official sues, wants, I believe it was back pay. And the question was presented to the court. There was a restriction on the president's ability to remove the postmaster. The president does not cite any ground for removal that would have related to the permissible reasons for removal. And the Supreme Court, in an opinion by Chief Justice Taft, who himself had been the president, goes through a long scholarly analysis of the history of the presidential removal power, walks through a debate in the 19th century about the Tenure of Office Act, which was a Civil War era statute, or I suppose I should say like right after the Civil War era statute, restricting removal, and essentially says not only does the president have an unfettered at-will removal power, but Congress cannot regulate it. There are certain maybe instances where the principle does not apply, even Myers acknowledges, but by and large, the Myers case stands for the proposition that the president has not only a background presumption of removal authority, but an unregulable presumption, an unregulable removal authority as pertaining to executive officials who are exercising executive power. The Supreme Court decides Humphrey's executor less than a decade later. There was scholarly discussion. There was some discussion in dissenting opinions in Myers about whether the rule of Myers would apply to the Federal Trade Commission or other independent regulatory commissions. I mean, the FTC, if you think of the timeline, had been established in 1914. Myers comes down 12 years later, seems, in the opinion, to disavow its potential application to the FTC. And then 9 years later, the Supreme Court's confronted with the question and says, to the extent we said anything in Myers that would have been inconsistent with the rule we articulate today, we're resolving that conflict in favor of the removal protections of the FTC.
Okay, so let's now jump into the case. What arguments did the president make through the Solicitor General? And maybe as you detail those, what was the reaction from some of the justices to those arguments?
Yeah, so the government came in, and it was Solicitor General John Sauer did the argument and made the point that Humphrey's Executor at this point is a case that just no longer has any appropriate legal foundation and should be overruled. So the government is going for all of it. They want Humphrey's Executor to be overruled. They describe Humphreys as having caused confusion in the lower courts. They describe Humphreys as being inconsistent with prevailing interpretations of the executive power. And in fact, it's correct that Humphrey's Executor describes agency power in a way that's largely inconsistent with the way that judicial decisions from the Supreme Court today would describe executive power. So the idea, for example, that there is this thing called quasi-legislative or quasi-judicial power as distinct from executive power that must be superintended by the president, or, by the way, that there's this thing called quasi-judicial power that's distinct from Article III judicial power that can be carved off from the judiciary without life tenure. Because remember, if there's some presupposition of the ability to remove, these officers don't have life tenure. If they're appointed to a term of years, as the FTC commissioners are, they don't have life tenure. There's this idea of quasi-legislative power. And I think the court has a more formalist view as to these powers. If you're going to confer legislative power, well, the only body that should be doing legislating is Congress. So the Solicitor General leans into this formalist understanding of how the structure of the government works and continues to go back onto separation of powers principles to make the argument that the court's more recent precedents point in the direction of Humphrey's Executor today being a barnacle on the Constitution and being ripe for overruling. I thought the court's reception to the Solicitor General's arguments was largely warm. It seems that the court may break down along familiar lines in favor of the government's position. I am not usually in the predicting game, but the perhaps likeliest outcome is a 6-3 decision in favor of the government's position, allowing the president to remove a commissioner of the FTC. There were some justices who were a little bit concerned about needing to go the whole way and actually overrule Humphrey's Executor. The Chief Justice in particular asks this question about, well, aren't the functions of the FTC today different than they were in 1935 when the court in Humphrey's Executor invalidated them? Justice Kavanaugh asks some questions about how this logic would apply to the Federal Reserve. Justice Gorsuch had some questions about whether really what we're looking at here is a removal issue or it's more of a non-delegation issue, that too much power has been delegated to an agency that's independent. And the last thing I'll say on this point is that the government and the justices questioning seem to focus a good deal on part one of the question presented, the discussion on the actual merits of the constitutional question that we discussed earlier. So whether Humphreys should be overruled, and even if not, whether the removal provisions violate the separation of powers. There was less discussion about the remedial question. And indeed, Justice Kavanaugh expressed some skepticism about whether, if the court ruled on the remedial issue, the government could do an end run around removal protections that are constitutional as to other federal agencies if the court doesn't reach it in its decision.
So let's stay on the president's sort of case and argument. What are the separation of powers principles that Humphreys violates, and because I think that may be simple, maybe, where, what is the constitutional basis for asserting that the president has the right to fire commissioners of so-called independent agencies, right? I think that's the core question. Both, all the justices were sort of focused on where does this authority come from? And I think there were some differences.
Yeah, I agree with you. So I think the first part of your question, what are the separation of powers? Where do these separation of powers principles derive? I think you would start with the vesting clause of Article 2, that all executive power shall be vested in a president. There was some back and forth with justices like Justice Kagan and Justice Jackson about, well, shouldn't Congress have some say here? Congress does have the power to create offices. And so maybe the necessary and proper clause, as the justices, at least Kagan and Jackson, I expect Justice Sotomayor would see it, doesn't the necessary and proper clause bootstrap that office creation power into the power also to define the limits of the president's power to remove principal officers at will? And the Solicitor General said no. Solicitor General's argument on that score was that this is just in the heartland of executive power. So Congress can create the office, but once that office is created, it has to be the president who has full-scale superintending power over that executive power. And that includes, of course, the ability to remove an official whose conduct may not rise to the level of inefficiency, malfeasance, or neglect of duty, but nevertheless does not go along of the same mind with the president's priorities, maybe enforcement priorities for a given agency. Justice Barrett asked what I thought was a good and important question in saying that the Supreme Court's decisions have discussed not only the vesting clause, but also the take care clause and the appointments clause in its removal power jurisprudence. And she asked the Solicitor General whether any one of those should be the hook that the court rests its ultimate analysis on. In fact, Justice Barrett suggested that a holding based on the take care clause or a holding that sees the removal power as an adjunct to the appointments clause, because it is true, the Constitution does not necessarily textually prescribe the president's power to remove, depending how you feel about the meaning of the term the executive power. But it doesn't explicitly textually provide for the removal power. And so Justice Barrett asks, do we need to ground it in any one of these three powers? Or is the court being imprecise, just kind of citing all three provisions? And the Solicitor General encouraged the citation of all three provisions, said that the rule does not need to be reduced to merely a take care clause rule or merely about the appointments clause or something along the lines there. And so I think where you at least get the separation of powers principles as to the executive power of removal over officials who are exercising executive power that must ultimately be reposed in the president, it's these three clauses taken together. But I think the government probably would prefer, if it had to pick one, the vesting clause.
So I thought that Justice Barrett and maybe some others were, in some sense, asking whether they could limit the extent of presidential power here, right? I thought, and this is really a question for you, I thought there was some concern about a very broad firing power within the presidency, and that it might extend to basically every employee of the government, and that might be unnecessary for purposes of this matter. And in fact, highly disruptive to the civil service, how the civil service has developed over the last 100 years, right? And I don't know what you made of that, but I thought Barrett was, I thought there were a number of instances where the conservative majority of the court was sort of thinking about a way to narrow the scope or effectiveness of their decision here. And I thought this was one way. What do you think?
Yeah, so I thought there were a few instances in which the court was very obviously thinking about the implications of the decision it is going to issue in this case on other cases, on other agencies, on other classifications of officers or employees in the government. So I'll say number one, there was a distinction drawn at oral argument between, or I should say among, principal officers, inferior officers, and employees of the government. I would recommend to the viewers' readership a great article by now Judge Jen Mascott about who are officers of the United States in the Stanford Law Review. But the question presented here really relates to principal officers, officers who are directly accountable to the president, as opposed maybe to employees of the federal government who have civil service protections. And the question whether the principal officers must be removable at will by the president seems to strike at the very heart of the president's ability to control the executive branch, because those are direct reports to the president. Here you have principal officers who lead a federal agency, and not just any federal agency, but one that has an awesome jurisdiction over not only competition policy in the United States, but also consumer protection policy in the United States. And so the idea that that would be carved off from presidential control, I think, is more troubling maybe to some of the justices than the question about whether employees must be removable at will. Now, it may well be the case that the Supreme Court comes back and rules in a later case if the question is presented on the employees question. But I thought what was more interesting at the oral argument was not so much that three-tiered distinction, but rather how the court was going to be able to distinguish between this agency in front of it, the Federal Trade Commission, and other agencies where there's an open question about whether presidential removal power is necessary. So the ones that the government continued to come back to and say, we also want these agencies, were the National Labor Relations Board and the Merit Systems Protection Board. Those agencies are currently also the subject of litigation. Judge Katsas, in fact, issued an opinion in the D.C. Circuit on Friday pertaining to those two agencies. And so it's likely that if the court doesn't directly resolve the question presented with respect to those two agencies as well, or at least in this case in a way that would telegraph what the correct outcome is as to those agencies, it's likely that those agencies would be the next ones before the Supreme Court. There was also, however, a lot of discussion on the more pushing back side about the independence of the Federal Reserve. The Solicitor General noted that the government has not challenged the independence of the Federal Reserve. Rather, there is a case indeed involving the removal of a member of the Board of Governors of the Federal Reserve. But that case is a statutory interpretation case about what the appropriate standard for cause is under the Federal Reserve statute. The president willingly submitted himself to the statute and articulated what he describes as cause for that removal. And so we'll see what happens with that case. But the Supreme Court, even in a stay order in the case pertaining to the NLRB member, said that the FTC might raise unique and distinct concerns. The court was also interested in the prospect of the extension of removal, or I should say at will removal, to Article I courts. And maybe the better way to describe these is non-Article III courts. So everything from, the tax court to the Court of Appeals for the Armed Forces, which of course all raise different types of issues. But yeah, I think the court was very concerned, and I imagine you'll see some discussion of this in the opinion about, well, if we rule based on the Solicitor General's logic in this case, what's that going to mean for all of these other agencies that also may or may not be on the removal power chopping block?
Yeah, no, absolutely. I had really not thought about, prior to listening, the impact of this case on the tax court or the court of claims. But let me. I think there were a couple of ways that some of the justices pushed back on the position of the president. Some of this was from, what I'll call the minority members of the court. I also thought Gorsuch was concerned about sort of undoing, the I don't know, he used, the minority members use this phrase more than others, this bargain between the Congress and the president in terms of what powers were authorized through the independent agencies, or specifically through the FTC. And I thought, just like in the tariffs case, Gorsuch, among the majority members of the court, was a little bit concerned about how or whether Congress could get power back if the structure of the agency or the president's rights with respect to the agency changed. Maybe you can talk a little bit about that, because I thought the what I'll call the minority justices, I think, had sort of a similar view.
Yeah, so there's an ongoing question about, once Congress confers power upon the executive branch, whether it's able to get that power back. You see this a lot in the context of the non-delegation debates. And so that also, of course, featured in Justice Gorsuch's line of questioning at the tariffs oral argument. But there's a separate question here, because the conferral of power here is not on the executive branch. It's on independent regulatory commissioners, folks who really are not formally accountable to the executive branch and not necessarily formally accountable to Congress, although there was some discussion at oral argument about how Congress does retain some powers through appropriations, through oversight, and the like. But there's this question of whether, if Congress has endowed an agency with independence, how easy is it for Congress to take that independence back? I thought that the respondent in this case made a fine point that if there are folks who are concerned about independence in the independent agencies, that one solution is to go to Congress and to ask for a legislative fix. But I thought what the ultimate fallback there is that might be right as a matter of political theory, but there still is a constitutional backdrop. And so there's certain things Congress can do, and more importantly, there's certain things Congress can't do. And often the Supreme Court is in the posture of reviewing a claim that Congress can't do something. So in that latter universe. And so here, right, like one of the parties to this case is the president of the United States, who says, I have been improperly restricted in my ability to remove an official of the executive branch. It's very nice that, at one point over 100 years ago now, Congress and President Wilson came together to place this limitation on himself and all future presidencies, but they weren't allowed to do that under the separation of powers. And so to the extent that it's right, there was this concern about whether Congress would be able to claw the power back. First, it's not obvious which way that cuts. And second, I think the case ultimately does come down to this constitutional rule that there are certain things in the separation of powers universe that Congress is restricted from being able to do.
Okay, so I think I want to come back to some of the pushback that the minority justices have offered to the president's argument. But before we do that, what was the argument of Commissioner Slaughter and her counsel in favor of retaining Humphreys? What was the argument?
Yeah, so the argument on the other side largely rested on precedent. And so there has been some scholarship about whether it's right as an originalist matter that the president had an at-will removal authority. And some of that scholarship butts up against some more recent precedents of the Supreme Court that I think the respondent, who was represented ably by Amit Agarwal, understood that the court probably was not going to get too much into. I imagine Justice Kagan is going to say a good amount if she ends up dissenting in this case, just as she did in Seal of Law, about the history here. But the respondent for Commissioner Slaughter attempted really to work within the precedents and make the point that there is no example of the Supreme Court invalidating a removal restriction for an agency that looks like this one, and that is an agency that is that's multi-member and a sort of very interesting argument that Justice Gorsuch seemed to take deep issue with, one that does not exercise what Commissioner Slaughter's counsel described as conclusive and preclusive executive power. Now, when pushed on that point, because of course the FTC, as we noted earlier, does a ton of things that seem like they're very much in the heartland of executive power, e.g., the ability to actually bring civil enforcement actions against private citizens in a way that it was not able to do without going through a whole adjudication proceeding, and really not being able to issue an order with much force back in 1935. Now it's able to do so. Commissioner Slaughter's counsel seemed to draw a line between civil enforcement and criminal prosecution. Now, Justice Gorsuch didn't seem to buy it, which is similar to a through line that has run through a number of his cases where there's kind of a civil criminal convergence. You see this in his jurisprudence, for example, about lenity or the void for vagueness doctrine, that civil penal statutes are to be interpreted in the same way and subject to some of the same constitutional restrictions as criminal laws are. But the argument was advanced that actually, if the agency is unable to do criminal prosecution or something else that would be considered a longstanding presidential power, so for example, engaging in diplomacy like at the State Department, then if Congress wanted to, it would have to do two things. One, it would have to turn the agency from a single-headed agency into a multi-member agency. That's the principle that Agarwal distilled from seal of law, and he says he has no problem with seal of law. So he distills that principle from seal of law, says it has to be a multi-member agency, and then it has to be an agency that does not exercise a conclusive and preclusive executive power, and describes those really as criminal prosecution, foreign diplomacy, and it wasn't clear how much else would get in there. So it's quite a broad rule for congressional power to regulate removal. Of course, he got questions about the FTC's powers today, distinguished those on this basis of the line that he attempted to draw between civil and criminal. And then Justice Gorsuch had what I thought was an interesting point in response, where he said, you're not doing as much defending of the reasoning of Humphrey's Executor itself. You continue to say it is an example of the court holding what it held 90 years ago about this particular statutory provision. But he said you seem to be backfilling the reasoning a little bit with this line between civil and criminal, just to try to establish a rule that would save this removal protection.
So I think there were a number of areas where the, again, what I'll call the minority justices, tried to support the idea of maintaining Humphreys. One, I think, was possibly how either a reversal of Humphreys or distinguishing Humphreys from the current FTC might lead to what I would characterize their position as upheaval in the administrative state. Some discussion of how we've sort of lived with this administrative agencies for 50 to 100 years, depending on how you sort of think about the extent of their powers. I think there was also this discussion of, which we touched on, this bargain between the Congress and the president. Congress had passed these laws, presidents had signed them, presidents had not. Pushed back on their restrictions. So I'd like you to talk about that, but I'd also like you to sort of highlight maybe one of the questions, I believe it was from Alito, or focus from Alito, which was, is there anything in that would prevent the Congress from converting or what we think of as executive branch agencies, like the Department of Commerce, Department of Education, into multi-member commission-style agencies, which would also limit the president's power to change or fire the membership. I mean, that struck me as sort of a powerful pushback on the idea of, the Congress has the power to set up independent agencies in the way they would like them to be set up.
Yeah, this was an effective line of questioning, I thought, from Justice Alito, and a tough one for respondents' counsel in this case. So I think that at least part of the theory here had to have been that Congress cannot regulate the removal of the Secretary of State, the Secretary of Defense, the Attorney General, and Respondents' Counsel throws in the Secretary of Homeland Security. But once those four were mentioned, it sort of opened the door for Justice Alito to say, well, what about the Labor Department? What about Veterans Affairs? What about Interior? And you saw Justice Thomas, the Chief Justice, Justice Kavanaugh, Justice Gorsuch, all sort of jumping in on these different agencies and trying to articulate a rule that wouldn't strike an ordinary observer of modern executive practice as one that would be outside of the mainstream of everyday understanding about executive removal power. I mean, there is no question that if, for example, the president determines that the Secretary of Veterans Affairs is doing a bad job in administering the veterans health care system, that the president is well within his rights to remove the Secretary of the VA. And so there's this follow-on question. Well, what if Congress turned the Labor Department into the Labor Commission and was able then to create a multi-member body that did a lot of the same stuff that the Labor Department today does? And then, if that agency existed, could Congress regulate removal? And I don't know that Petitioner's counsel was really able to distinguish those agencies from the rule that he was trying to articulate in a way that was to the satisfaction of Justice Alito and some of the other justices who were interested in this question. Because I think for some of those justices, they would be very skeptical of writing an opinion that establishes a rule that allows Congress to carve out of the president's executive authority agencies like the ones that have traditionally been thought of as executive agencies. This is where this case gets difficult, because the FTC does many things that an everyday executive branch agency does. Its initial mandate was more adjudicative. It was set up sort of like a court, but importantly, not a court. It's this administrative tribunal type thing. But it brings original actions in federal court. It creates rules. It does things that when the Labor Department does them or the Agriculture Department does them, those are traditionally understood to be well within the president's ambit to control and ultimately remove the head of the agency if the head of the agency is not doing what the president wants that person to be doing. I will say, however, you had three justices who you've described as probably more likely to be in the minority in this case, Justices Kagan, Sotomayor, and Jackson. And what you had with their questioning was more of a seeming awareness of the possible consequences of what this rule could yield. Now, the justices who are likely to be in the majority said, on the way back, that it's unlikely that these consequences would come to pass. But Justice Jackson, for example, was very worried about the prospect of the president being able to clear out entire agencies and remove expertise from those agencies. It mentioned, for example, the Nuclear Regulatory Commission or the Surface Transportation Board as possible candidates for hollowing out, and just believes that as a matter of public policy would be bad. And so maybe as a matter of constitutional law, the necessary and proper clause gets you there when Congress endows an agency that it believes needs to exercise scientific expertise and sober judgment outside of the political process, that maybe it is necessary and proper to carve that agency out of the usual rule that the president can remove. But I thought the government was effective in rebutting that, of just, at the end of the day, that these are executive powers and they must be wielded by the president.
Do you think, one thing I did not hear during the argument, a discussion of how some of the FTC's powers, in a sense, I think maybe more than in a sense, overlapped with the powers of the Justice Department Antitrust Division, right? They both, under different statutory rights, can go into court, to block a merger. In one case, just on the preliminary side, but they can also go into court to attack, anti-competitive conduct. I mean, we saw the FTC's case against Meta just failed, but that was in district court. That I think highlights this, two agencies, two branches, whatever you want to call them, two agencies doing basically the same thing with sort of a different rights that the president has. Does that illustrate the problem sort of clearly for the court, even though it didn't seem to be argued?
So I thought the closest that the court came to addressing what you describe is when Justice Alito proposes another one of these hypotheticals, and he's great at these during oral argument. And he says, well, what if Congress split up the Justice Department? This is amid the colloquy about whether it's appropriate to look to criminal prosecution as the line for whether executive power is being exercised, and thus at will removal is necessary as a component of the executive power for a given official. And he says, well, what if Congress split up the Justice Department into two parts? He says, you say that the Attorney General cannot be protected from at-will removal. Well, what if there was the criminal attorney general and the civil attorney general? So the Justice Department, part one, right, is the criminal enforcement. And, I think under respondents' preferred rule, that would be a department where Congress would be unable to regulate the removal of the principal officer. But as to this second type of agency, the civil department, that's one where maybe on the rule that's articulated here, you would be able to carve it out from removal. And I think the respondent at that point, had painted himself maybe into a little bit of a corner of what some of these agencies look like. He says there, for example, that there's some historical traditions about functions and the like. But it is true that there is a good amount of overlap between the FTC and the DOJ. And so to the extent you concede that the DOJ is an agency that it would be really difficult to preclude the removal of its principal officer, then when I tell you the FTC does a lot of enforcement activity in the federal courts on behalf really of the United States, I mean, it's on behalf of the FTC, but it's really on behalf of the United States, to say that you can't then remove the FTC commissioners, I think you'd need a little bit more there. Now, respondent would say, well, part of what's going on here is that there's a multi-member agency, which is maybe a little bit less subject to abuse than a single member or a single director agency like this sort of hybrid DOJ criminal. And so you amalgamate some of these precedents together. But you have a little bit of a line drawing issue by the time you get, to trying to put these precedents together in a Frankenstein type manner. And I think the court would be worried if it did that, not only that it would be getting the law wrong, but that it would have to answer this question as to every agency in the federal government, as opposed to establishing a cleaner rule about the exercise of executive power being necessary for the president to be able to superintend, at least in part, through the removal power.
So that plays into my next question, which is, what is there only one remedy here, or only one, outcome here, right? We heard during the oral argument a discussion of severance, which, if I remember right, I think about, we could allow for these congressional restrictions if we remove the executive power from the agency. One, is that plausible? Is it something the court can do in this case? And does it do exactly what you were just alluding to, which is lay the groundwork for the courts, to start sort of restructuring every agency, every independent agency, which has this amalgamation of executive and non-executive powers, as a plaintiff brings a case, right? So is there an alternative remedy here that takes the FTC back, to its origin, basically, in terms of powers, or is that just totally unrealistic?
No, I think it's something that the court was very interested in during the oral argument about what exactly to do with this statute. I mean, it's been argued in other cases. So you can imagine, for example, a putative enforcement action by the FTC. It has been argued that the FTC cannot bring affirmative litigation because if it were to do so, then it would be unconstitutional under Humphrey's executor itself, because now it's exercising powers that Humphrey's executor did not conceive of when it issued its rule of constitutional law as to the removal protections. This is kind of the flip side of the argument that I end up making in the article, that after 1935, after the question as to the constitutionality of the removal protections is settled, with reference to the functions of the agency, now you have a second order problem, that you have an agency that has all of these powers that look a lot more executive, that the court and, for example, seal law would tell you are executive, but it's still subject to these removal protections. And so perhaps it's the case one's got to go. Now, the relief that Commissioner Slaughter would want here is to sever not the removal provision, but to sever maybe the powers. In fact, I believe that counsel for Commissioner Slaughter, I believe that Mr. Agarwal says I would be okay with the severing of the powers, although I'm not sure he was as full-throated or excited about that prospect. If that's right, I think part of the problem here is that the requested remedy is to remain in office. And so the constitutional question comes down to, is this constitutional power, or is this power one that supersedes the removal protections, Article 2 constitutional power? Once you get into, like, when we start carving off other powers that the agency has gotten after 1935, you run into a couple of different hurdles. Number one is you have to agree that the powers as of 1935 that the FTC enjoyed were themselves not executive. I don't know that there's a majority on the court that believes that. Now, maybe just as a rule of stare decisis or precedent or whatever else, maybe that argument would have more purchase. But first, you would need to agree that would be, the correct resolution of the case. And then second, you would need to articulate a theory of statutory severability that gets you to this sort of remedy, which is the removal protection is upheld, and we just don't think that these other statutory powers that really weren't at issue in this case or in the briefing are unconstitutional for Congress to have added. There's a third option, of course, which is that the court just says the FTC is unconstitutional, full stop. We're not severing anything. The whole, if the removal provisions fell, then Congress would rather have not had this agency exist at all. I would be shocked if the court did that in this case. And there didn't seem to be much of an appetite in that case. But Agarwal continued to go back to this idea that some of these remedial questions are analytically distinct from some of the issues that are before the court. And I think he would have been okay with the court remanding for further briefing on some of these remedial questions, although I doubt that the court, after having already granted cert and done an oral argument and everything else on a question of constitutional law, where it's likely that a lot of the justices have very settled views on the issue, are going to do that as to severability, and probably will just say the removal protections are unconstitutional.
I thought there was one series of questions that came up focused on if the president has the authority to fire these commissioners, and if you think of that, the commission as within the executive branch, Congress has now delegated what you might call legislative functions to the commission, rulemaking powers, for example. Now, some of the executive agencies have rulemaking authority too, but does that raise questions? Again, a separation of powers questions, right? Is the president now have a legislative function or right if he is in fact in control of these so-called independent agencies? And how does that raise constitutional questions that the court may take account of?
Yeah, so Justice Gorsuch seemed to be especially concerned about the prospect of delegation to federal agencies of legislative power. The doctrine, as we discussed earlier, that often comes up in these sorts of discussions is the non-delegation doctrine. This is a principle that Congress cannot delegate legislative power to the executive branch. Can't delegate legislative power to anybody, but often it comes up in the context of a purported delegation to the executive branch. Justice Kavanaugh noted he was especially concerned about the issue of delegation of legislative power to independent agencies. But I think to answer that question or to tackle that issue, we'd need to formulate a working theory about what exactly constitutes that sort of power. So when we, for example, talk about delegation of legislative power, what do we mean, and how do we know that, for example, Congress has done something that may well be okay? Where you'd start, I think, on that score is the court has articulated a test that Justice Gorsuch takes issue with called the intelligible principle test. The intelligible principle test largely stands for the proposition that as long as Congress has supplied an intelligible principle about how the executive is to, for example, make rules or exercise otherwise delegated authority that may look legislative, as long as that occurs pursuant to an intelligible principle such that Congress has made the appropriate policy choice, there has been no delegation of legislative power. Now, the FTC fleshes out broad statutory mandates. It defines terms like unfair methods of competition and unfair and deceptive acts and practices. And so if there is a non-delegation objection to this broad power that has been reposed in the Federal Trade Commission, number one, you may be more concerned about that power because it's exercised by people who are not democratically accountable at all because they're not removable by the president. But I think Justice Gorsuch would be just as concerned, or maybe still very concerned, about the exercise of that power by the executive branch, because in that sort of situation, you still have the executive branch engaging in effectively a legislative function when under our Constitution, the only body that's able to do legislating is the Congress. And so whether, if Justice Gorsuch's view prevails, that yields a more robust intelligible principle doctrine with teeth, or it looks something more like the standard that he laid out in his dissent in Gundy v. United States, where there's certain categories of power where we would be especially concerned about Congress delegating, and maybe we need a little bit more than just an intelligible principle, although line drawing is tough in this space. I think that the non-delegation issues lurk in the background, but the Solicitor General was very clear to say, I don't think that this is a non-delegation case. I don't think this is, as Justice Kavanaugh appears to have suggested, a major questions case. This is a case about vindicating the executive power to superintend the executive branch through the removal of officials whom he would rather not exercise executive power on his behalf.
So let me ask sort of a similar question with respect to the commission's adjudicatory power, right? I mean, the commission itself can put cases, what we otherwise would think of as litigation, into its administrative system, where an administrative law judge or maybe a hearing examiner makes a sort of an initial decision or recommendation. That goes to the commission for review. Commission can write an opinion that has the force of law. It can be appealed to the appellate courts and, of course, the Supreme Court. But, does this raise the question of whether the president is engaging in a judicial function, the executive branch in a judicial function, and does it eventually make that function go away?
Yeah, and seeing as we're coming up on the hour, I'll answer this one because this could be the subject of its own webinar, and so maybe we'll put a bug in the ear of the FedSoc people to do the next webinar on this one. The question of the executive branch exercising effectively adjudicatory power or engaging in adjudicatory functions is one that I think is ripe for review. The executive branch has engaged in adjudicatory functions for a while. There has been a substantial body of constitutional law that is built up around, for example, the existence of administrative law judges in the executive branch. But some, like Justice Thomas, have called this into question on constitutional grounds, and I'm interested to see where the Supreme Court goes on it if that question ends up being presented.
All right, I think we are at about 3:00. I think we're basically done. I apologize. I did not get to the specific questions in the Q&A, but I think we touched on them. So I don't know. I'd say thank you. Thank you, everybody, for sticking around and for doing this.
Yeah. So on behalf of the Federalist Society, thank you both for your time and expertise today. And I want to thank also our audience for joining us. We welcome listener feedback by email at fedsocforums@fedsoc.org. As always, keep an eye on our website and your emails for upcoming webinars. So thank you all for joining us.
We are adjourned. Will be available on the website.
Indeed. Yep. Thank you.
Thank you, everyone.
Thank you for listening to this episode of FedSoc Forums, a podcast of the Federal Society's practice groups. For more information about the Federal Society, the practice groups, and to become a Federal Society member, please visit our website at fedsoc.org.